All right, we're already off to an exciting start with a great witness to begin our day. And also, I have a great guest to start with right now. She's joining us all the way from California. Career trial attorney Wendy Patrick is back with us. Wendy, it's great to see you.
Always a pleasure, Jesse.
Now, this witness is very important because it helps establish, I guess, the motive here. So the prosecution, why are they putting him in?
Well, you know, prosecutors want to make sure that jurors understand why somebody was motivated to commit the crimes they commit. Who started it, right? We know that when our kids are fighting with each other. How did this start? Now, while some crimes you don't need to prove motive, motive matters to jurors, particularly when you're trying to decide what is it? Is it first degree, second degree, involuntary manslaughter, whatever you want to call it, negligent homicide? We have so many different gradations of crimes that this kind of testimony is important to figure out what would motivate somebody to do this to begin with. Most of us can't understand why anybody would commit murder. It makes it easier if jurors at least understand what went into this relationship.
Yeah, and here what we're trying to establish was Muhammad Knight the victim? Was he the aggressor? Was he upset at Armando Baptista that night because of what happened with this witness, Walter Stanley? And if apparently Walter got into some sort of altercation with Armando Baptista, the story makes a little more sense.
Right.
But unfortunately, this whole situation doesn't quite make a ton of sense. But that's okay. Let's take a quick break, and I think that's what we have to do. We have to take a quick break, and when we do, when we come back, we'll be live in that courtroom. And let's not forget, we're also going to be live in the Nicholas Godejohn trial a little bit later on. We'll be right back. You know, the law can get complicated at times, but that's okay. We got with us Wendy Patrick to help explain. Wendy, what's going on here? It sounds very complicated. Some hearsay issues. What's happening?
You know, it sounds complicated, Jesse, but it really goes to the heart of the issue. Who said what? And, you know, you look at provocation and predisposition. When you look at both of those things, when there's been a fight, and I'm going to put air quotes around that because it's never a fight. There's an aggressor and there's a victim. There is words that maybe explain why it started. There are words that explain motive for why it started. But remember, there's also this issue of reasonable use of self-defense. So the language that the parties used are vitally important for a jury to understand how this unfolded. And it also goes to the credibility they're going to assign to what the defendant said, what the victim said, and ultimately who's to blame and whether or not these charges can be proven. And
it's all important about what was the potential motive here.
That's right.
Because if they can establish, again, the defense that Muhammad Knight was in fact the aggressor and that he wanted to hurt Armando Baptista, and you back that up with the idea that there's glass and blood found in Baptista's vehicle, it starts to lend a little bit more credibility to their story. Having said that, what you heard from Walter Stanley when he was on the stand really wasn't that beef that they keep describing. So I think we have to take a quick break, but that's okay. Oh, okay, actually, not yet. We can go back to court right now. Walter Stanley's back on the stand, so let's go. All right, so this is becoming very complicated about how to impeach this witness, and again, with what statements they can use. We'll talk about that in a second, but I want to bring back on Joseph Scott Morgan, because Joseph, we unfortunately were cut off before, and we were talking about trying to analyze this crime scene. So if you're looking at a crime scene, or you're looking at the victim, what are the things that you're looking for to see some sort of area of self-defense here? You know, again, Armando Baptista is claiming that he was acting in self-defense. And we know there's the presence of whether or not Muhammad Knight was carrying a beer bottle, and even whether or not it was actually a broken beer bottle. So when you're looking at both maybe injuries from Baptista or the victim, what are the kind of things that you're looking for in a self-defense type argument?
Okay, well, to the point of self-defense, if our viewers at home will just kind of take a look at the back of their hands and this highly raised knuckle that we have right here where our fingers conjoin, these areas will actually have points of abrasion, particularly if there's like a fisticuff that's involved, where these areas will be scratched, they'll be dinged up. There'll be some interesting kind of little abraded areas. Some of them might be semicircular, that sort of thing. And one of the things that's key here is to see if these types of injuries are consistent with someone that is actually engaged in a fight. Another point of order here is the idea of aging these insults that are on the backs of the hands. Are they in a state of healing? Because that gives us a specific timeline. If someone is trying to alibi themselves, if you look at it and you see that these are not fresh, then that gives us an idea that the individual was engaged sometime before that is not necessarily consistent with that particular incident. But what is essential, Jesse, is that the investigators at the time, at the specific time in which they first bring this guy in custody and begin to interview him, he is thoroughly examined on all aspects of his hands, his face, and even his forearms. Some people block punches, some people throw punches, and you want to check the face to see if there are any insults there where maybe somebody scored a strike to the face.
And talking about the crime scene, I got to ask you this too. One of the things we heard was that there, whether or not there was a red Solo cup in the area, because if the prosecution can establish that Muhammad Knight was carrying the red Solo cup, then it really doesn't look like he was an aggressor. It'd be different if he was carrying a beer bottle. Now, at the crime scene, there was a broken beer bottle, but there was a red Solo cup, but that was found the next day. My question to you is it strange that an investigator would look at the crime scene and not see that red Solo cup? Now, again, there's a question of, well, I went at night, then I went back the next day and saw it during the day. I canvassed the area when there's more light out. But is that strange to you?
Not necessarily. If you're talking about in a highly congested, highly traveled area, yeah, I mean, it's possible that you're not going to see everything, particularly at night. And I'm not trying to make excuses for the investigator. It's just, there are limits to what you can do in a low-light environment. As a matter of fact, even after your eyes become adjusted many times, everything sometimes looks the same to you out there. That's why we do go back out in the light of day and take a look around in those environments. I think what's kind of interesting here, I've heard talk about there being glass in the vehicle. That's Mr. Knight's vehicle, I believe.
No, it was actually the car that was in,
in
Baptista and Elder. That was their car.
No, was any of that glass extended out to the periphery around the, around the car? Was it simply contained within the car? Because also, you don't know what other kind of debris is floated in here. Maybe there are people that just ride through there and they throw bottles out of the window. They were coming from a party that was there. I don't know, and that can be argued. So we would have to do things like matching of glass and that sort of thing, if the glass was even collected and matched or examined.
Yeah, no, it's a fascinating discussion about what ultimately happened using that evidence to back it up. I'm also here with Wendy Patrick, and Wendy, I have to ask you, you had mentioned to me in our break as we were listening to this, the idea of an unreasonable self-defense.
Right.
Can you talk about our viewers about what that means?
Well, you're allowed to use reasonable self-defense to defend yourself. You're not allowed to go above and beyond, over the top, and use an unreasonable amount of force to defend yourself. That's why it's so important as to who brings what kind of a weapon to an altercation.
This is a stand-your-ground state, though. We're talking about Florida.
It's the same thing, though. You got to look at what you faced with in order to decide whether to retreat. You're allowed to stand your ground, and we've talked about a lot of Florida cases, but nonetheless, that's why this is so relevant, as they're looking at, was it a bottle, was it a cup, who had what? In other words, what did it look like to the supposed victim? Did it look like a scenario where you were going to use a particular amount of force? That's why it's so important, not just the motive, but what were the facts that this victim was faced with when the defendant got there?
We saw the defendant's, well, let me rephrase, we heard the defendant's interview with the DA. Right. Very compelling for self-defense. Do you think it's necessary for him, despite that being presented to the jury, for him to take the stand? Oh,
what a great question, Jesse. So, I'm a prosecutor, but I started my career as a defense attorney. That's a decision that has to be debated and brainstormed long and hard, because you're right, the evidence could speak for itself, and sometimes there's no upside to putting a defendant on the stand and subjecting him to impeachment in a case like this, where tempers may be aroused through cross-examination, for example. So it'll depend on what kind of evidence they can elicit without having to make that ultimate call. He'll be the last witness if he testifies, but if they can do it without him, all the better.
All right, well, we're going to have to see one way or another. Let's take a quick break, and when we come back, hopefully we'll be live back in the Baptista trial. All right, everybody, welcome back. We are live in the Armando Baptista trial. Walter Stanley is back on the stand, and I know there's been this back and forth about whether or not these statements can come in. Can they be used to impeach him? It gets a little complicated. He looks bored on the stand. I'm not going to lie to you right there. But he's an important witness, because the question is, did he get into a fight with Armando Baptista back in the day? And was that a drive for Muhammad Knight to step in at this after this party and get upset and try to fight Armando Baptista on his behalf as a form of revenge? That becomes the question. Well, they're in a sidebar right now. Looks like he's leaving the stand. You know, back here with Wendy Patrick. Wendy, not easy being a witness, and clearly it gets a bit confusing. So just for our viewers, this becomes complicated in the sense of trying to figure out what statements you can use to impeach the witness, because the whole question is whether or not Muhammad was told by another individual, hey, I want you to take care of Armando Baptista, or hey, Muhammad saying proactively, do you want me to do something about Armando Baptista? That becomes a big question.
It does, and you know, these precursor questions, we'll call them, that lead up to an altercation like this are so important for the jury to understand the motive and the way it all was laid out, and also why the victim and the defendant were at the place they were when this occurred. But you're right, what we're seeing a little bit of is it gets complicated, is everything has to come in above board, and there's so many hearsay exceptions to argue about. You're right, a witness ends up being stuck on the stand listening to lawyers litigate the admissibility of statements that he or she wants to provide because they're just there sworn to tell the truth. But it does matter because motive matters, especially in a case like this.
It really is a very interesting discussion about that. And I want to bring back in Joseph Scott Morgan to ask a different aspect. You know, Joseph, the movies portray a beer bottle, broken beer bottle, as a very dangerous weapon. I've seen movies where they put it in the guy's jugular and it kills him. But really, in reality, how difficult is it, if in fact Muhammad Knight did have a beer bottle, whether or not it was broken or not, how difficult is it to wield that as a weapon and use it to really harm or even kill somebody?
It's effective. It's an effective first strike weapon, but after that, it diminishes greatly because the thing's going to fracture and it's not really going to hold together for any protracted period of time. The glass is very fragile. And it is in fact lethal. There have been any number of cases where people have, you know, I know of one case where somebody took a whiskey bottle and a very stout whiskey bottle, broke it and almost decapitated a fellow with it. But those cases are outliers as opposed to the reality of just taking some beer bottle, you know, the brown type of glass that we're commonly used to, and facilitating that as a weapon. Given a choice, I think an individual would choose a knife over a beer bottle. Knives are made to cut with. It's just that, and they're machined, so much more resilient. But you know, you have to. This goes to state of mind and perception. If you are perceiving yourself to be in danger, maybe you have. You're arguing that you've retreated to that last point. And you are in fear of your life. You know, that's the catchphrase, isn't it? In legal parlance, if you've retreated to that last point in fear of your life, you know, I got to do what I got to do. I got to defend myself. I got to protect myself. Yeah. And it's all about the defendant's perception.
And it seems that his perception was that that beer bottle was a weapon. Yes. You know what? They're having some arguments right now in court. So let's go live and listen to what's happening. Okay, I guess you know what the great thing about being here on Law and Crime is? You get the reality of the trial, and sometimes, Wendy, it just, like, what does it do to a jury when they're sitting out there? They haven't been in the courtroom for now about 20 minutes or so, maybe 30, because they're waiting to figure out all these issues. Like, what goes on in their mind? Are they saying, well, what's really happening? We saw this witness on the stand. Then all of a sudden we're kicked out. I mean, what really goes on in their mind?
Well, Jesse, I've been trying cases for 23 years. Please, nobody do the math. But let's just say I've spoken to many jurors about exactly that question. What do you guys talk about? What did you think about this? They wonder whether it is significant that they've had to sit outside for so long, and that can be dangerous. And sometimes what jurors remember is drama. They remember objections, they remember things that seem to rattle the lawyers, and they attach significance sometimes to evidence that seems to tie up lawyers and the judge in arguments or in this kind of protracted litigation for longer than necessary. So when they come back in, the first thing they're going to think about is finally we're going to hear what the lawyers and the judge feel is very important, and that's as a strategy, something those lawyers have to make sure they take into consideration when they decide how are they going to reopen, re-dive into this examination, and what are they going to present.
Yeah, it's that was a great way of explaining it. I don't think they're going to get that explanation about
no, they won't.
What happened. Joseph, I want to come back to you. One of the conversations that's happened in this case is there's been an accusation that Muhammad Knight was on a certain substance called flakka. Are you familiar with that?
Yes, I am.
What does that do to an individual? So if we're assuming that he was on flakka, what exactly is it? What does that do to somebody? Because we're trying to understand who was the aggressor here. Yeah,
well, it has the tendency to kind of drive many primal urges. Let's see, how can I describe it? It causes many times hallucinations. It causes heightened levels of paranoia, that sort of thing. So, yeah, I could see it as a driver potentially, that it's going to put the individuals into an altered state, and not a good one, and very, very dangerous. And not to mention, let's keep in mind, he's got kind of a lethal cocktail on board. It's not simply just flakka. I think that he's fueled by alcohol. There was another substance involved as well. So if we just took flakka by itself, that's dangerous enough. But when you begin to kind of mix these things and marry them together, it becomes kind of a toxic stew. You don't know what's going to happen. Yeah, we still don't know what happened. We still don't know what happened. No, we don't.
And Wendy, I got to ask you this. We have the privilege here of being able to compare this trial to the Demetrius Elder trial, the co-defendant of Armando Baptista. Now, that's our privilege. We get to see it. Our viewers get to see that and compare it, especially comparing the testimony of a witness like Wendy Gonzalez both times, who was the girlfriend of Muhammad Knight. But we know that Demetrius Elder, who too was charged with manslaughter, he was found guilty of culpable negligence. When you see the jury convicting him of that lesser charge, what does that tell you?
It tells me they were perhaps wondering what kind of liability he really had, and maybe they were thinking about gradations of self-defense and do they give him the benefit of the doubt. We see this frequently, Jesse, and I hate to say it, sometimes it goes against the judge's instructions. Either somebody believed in self-defense or they didn't. What do the jurors believe? But if they're really not sure, and they're not supposed to do this, but it's possible sometimes they reach a compromise where they're not entirely sure, and that's within their purview, that they may decide he is guilty, but certainly not of the most important and serious charge they could have found him guilty of. We do see that where there are significant mitigants that they have taken into consideration in deciding what happened here and how much culpability lies on the defendant.
Yeah, and we're talking really, Joseph, about 2 against 1 here. Armando Baptista, Demetrius Elder against Muhammad Knight, and at the end of the day, Muhammad Knight was the one who was wound up dead. He was stabbed multiple times, father of 4, had a 5th baby on the way. Just a tragic case. It all happened after a party, which seemed everybody was having a good time. So the idea that it was 3 individuals, but it was 2 against 1, how does that play into your analysis? Well, for me, it begins to, if you're talking about just the forensics here, okay, for me, it increases the layers that are involved in this case, you know, who was involved. And it goes back to what did the police do in the interim, you know, immediately following, rather, the event when arrests were made and this sort of thing. Did they reach out and collect evidence appropriately? Did they check these individuals for injuries? Were clothing collected? All these sorts of things, and how were they processed? Now, as far as the dynamics of the event, I'm going to be curious as to individuals making contact with the deceased. You've got 2-on-1. It's been reported that he was being struck by both individuals, that he was being kicked, this sort of thing as he made his way back. I believe, if I'm not mistaken, this comes from the interview with a girlfriend, all the way back into as they retreat toward the vehicle. So at this point in time, if there was a threat, it's greatly diminished at this time. And this, you know, this goes to, you know, you were talking about stand your ground just a moment ago. Well, it's no longer about standing ground. You become a dominant aggressor because you've got a teammate at this point, and it's one guy that you're going head-to-head with. Now, granted, the girlfriend, I'm surprised the girlfriend was not severely injured in this, particularly if we begin to talk about the drug mix that's on board. Now, that's a huge point. We've seen our chatters and people talking about it. The idea of, well, if there was this really big altercation, how come she had no injuries? And again, we're all trying to question what happened that day, and all we know is that Muhammad Knight is the victim here, and we're trying to understand how this happened. Let's take a quick break. When we come back, hopefully we'll be live back in that trial. Stay tuned. Welcome back to Law and Crime, everybody. Thanks for joining us. And now we have to talk about something that is really big here on the network. Yes, we're live in Armando Baptista. Well, we have a feed in the Armando Baptista trial, but nothing's really going on. So we want to focus and shift gears on a major case that we're covering here, and that is the Nicholas Godejohn case, the man who's on trial for allegedly murdering his girlfriend's mother. And why would he want to kill his girlfriend's mother? Because he's alleging that he was manipulated by his girlfriend to do this because she was the victim of her mother, Dee Dee Blanchard, that Dee Dee suffered from a strange syndrome called Munchausen syndrome by proxy, in which she basically fooled the entire world into believing that Gypsy, her daughter, Nicholas's girlfriend, suffered from a wide variety of ailments, including leukemia, and actually had her daughter wheelchair-bound for years. And that when Gypsy figured out what was going on, she snapped, wanted her mother dead, and wanted to live a free life with her boyfriend. And the only way to do that was to ultimately kill Dee Dee Blanchard. Now, I'm not kidding you. These are the details, and they are strange. Now, yesterday was day one in that trial, and we're waiting for the live feed to begin, and we will go live there. But in case you didn't see the opening statements by the prosecution and the defense, here's a special report of what that looked like.
Eyes are on Missouri for the trial against a Wisconsin man accused of stabbing his girlfriend's mother 17 times. 28-year-old Nicholas Godejohn and his girlfriend, Gypsy Blanchard, are accused of killing Gypsy's mother, Dee Dee Blanchard, who was discovered in a pool of blood in her bed in 2015. Prosecutors began their opening statements by pointing the finger at Gypsy as the mastermind behind the murder. The state then focused on the defendant, claiming that Godejohn was just as responsible for Dee Dee's death.
Outside of Claudine Blanchard's bedroom door stood the defendant, dressed in all black, wearing blue latex gloves, holding a knife. It was a year prior when the defendant, while speaking with his girlfriend Gypsy, was first introduced to the idea of killing Claudine Blanchard.
The defense fought back, countering the state's narrative by downplaying Godejohn's role in the murder, stating that Nick was just going along with Gypsy's plan.
Gypsy knew there was only one way she was going to be able to spend a life with Nick. There was only one way to get out from under the grasp of her mother, and that was to kill her mother. Nick arrived there at the house. Knife was ready, gloves were ready, tape was ready. He entered that home and saw Gypsy standing there, and Nick went through with Gypsy's plan.
Godejohn's team also introduced the defendant's autism diagnosis, arguing it explains the dynamic of the couple's relationship and Gypsy's power over the defendant.
You're going to hear testimony about Nick's autism. You're probably going to hear from a couple of doctors who are going to tell you Nick is autistic. He has a low IQ. He suffers cognitive disabilities. Nick wasn't able to formulate the necessary mental state to commit murder in the first degree.
Godejohn faces the possibility of life in prison if convicted. For the Law and Crime Network, I'm Aaron Keller.
Great reporting by our very own Aaron Keller on that, and now we got to break it down because we are going to be live in that courtroom and we have to understand all of the issues, the legal issues, the medical issues associated with this trial. And joining me are two very special guests. First up is career trial attorney Wendy Patrick, and also forensic death investigator from Jacksonville State University, Joseph Scott Morgan. But Wendy, I want to start with you. The defense is saying autism. He could not form the requisite intent needed for first-degree murder. What does that mean?
Very, very common to have the defense not deny the crime, but inject an element of mental defense. So what are they thinking of here by talking about autism? That he didn't understand what he was doing met the requirements to be guilty of the biggest charge he could be guilty of, which would be first-degree murder. But it's ironic that it's being introduced in a case like this, where it is Gypsy who was portrayed as suffering from mental defects, where they're actually spinning it and saying she was the master manipulator who actually manipulated this defendant to doing what he did. So the dynamics are fascinating, but they're also very relevant for the jury to understand. Now, they've also got to believe it's true. In other words, many people know autistic people that do not suffer from being able to actually be talked into committing murder. So it's not true that this is definitely going to work. It actually, you run the risk of putting off some of the jurors when you put forth a mental defense like this to explain a crime this heinous.
That he's the victim who was manipulated by a victim.
Because of the autism, Jesse. You know, there's some mental defenses that maybe would carry more weight with jurors, but that's what expert witnesses are for. And that's why it's going to come down to a battle of the experts. Does this qualify as something that could negate that specific intent?
Okay, and Joseph, let's focus on Gypsy right now. Gypsy claims that she was the victim. That she was the victim of her mother, who suffered from Munchausen syndrome by proxy. Now, for anybody who doesn't really understand this, we've talked about it before earlier in the program in the past week, but your perspective on this syndrome and how it plays into this case, I'm eager to know.
Yeah, I've dealt with several Munchausen cases over the course of my career, either commentating on them or actually working them. And interestingly enough, they generally involve really small children. I'm kind of amazed that Gypsy made it to full adulthood, actually. I've actually commentated on cases where mothers have literally killed several babies over a course of time so that they could essentially reap the reward that comes from the acknowledgement of their grief and all of these.
In other words, they make their child sick. They actually do take a deliberate step, which we don't believe is so much the case here. Or did you see something different?
Well, you know, going back in time, when you look at Gypsy's case, you've got a young lady here that had Roundup weed killer applied to her over a protracted period of time, where she had gone through multiple surgeries, and it's almost, I've heard the term BDSM come up in here, you know, periodically, where they're talking about these body modifications that this young girl had to go through, eye surgery to just eyes that were essentially there was no problem with, having an indwelling feeding tube, the dominance that this woman exerted over this child throughout her developmental years cannot be ignored in this case. I think that it eventually arrived at a tipping point. I am not a psychiatrist, but when you begin to see how this homicide was played out, how it was acted out, I think that this young girl probably felt like she was still trapped and was looking for a facilitator. Unfortunately, Mr. Godejohn was easily manipulated. And he is, in fact, I think, a victim to a certain degree. But he is a victim that inflicted 17 stab wounds to this woman while she was sleeping, and you just can't get past that.
One of the things that we're seeing as you were speaking, Joseph, and articulating this, is how much more happy, I mean, she appears to be in prison with her hair grown out. And again, the motive that the prosecution wants to say is that she wanted to be free of her mother. And who could help her? Nicholas Godejohn. Now, I want everyone to stand by because we're going to play some of the prosecution's opening statement where they articulate this and say that Nicholas acted deliberately, and he made that choice, a conscious choice, and knew what he was doing. Let's play some of that opening statement and we'll talk about it. All right, let's analyze this. First, Wendy, to you. He's making some interesting points there about the deliberate nature of what the defendant did, because it becomes really interesting when we talk about an autism defense. What did you make of his opening statement?
The prosecutor is laying out each and every step that he's going to then argue in closing statement and is going to establish throughout the trial is necessary to show the requisite mental intent was in fact there, despite the fact that the defendant may have suffered from autism or anything else for that matter. Because what the jurors are going to look at, they're going to look at not only what was he diagnosed with and maybe what does he truly have, But what did he do? And how what he did step by step, I wouldn't be surprised if in closing argument the prosecutor makes them sit quietly for 1 minute, demonstrating how long that can be as he stood there deciding what he was going to do. Not to mention the fact that he could have grabbed Gypsy and ran. In other words, murder was not the only solution out of this.
Okay, and Joseph, let me ask you real quick. The idea is, can you have somebody who's autistic, be on the spectrum, be manipulated by someone else, but still be deliberate in their actions, know what they're doing, and make that conscious choice and premeditate on it? You see what I'm saying? I mean, how is the jury going to sort this out?
That is an excellent question. I found one key piece here that was referred to just a second ago. When he contacted Gypsy, he wanted to know if the knife was ready. If there was an available knife, that she had it ready. And this goes to the planning aspect. Are they going to present her or continue to paint her into this idea that she is a puppet master, kind of directing him? How easily manipulated was he? What will be very interesting is we talk about this spectrum that autism is rated on and this sort of thing. When we get to defense, I'm going to be captivated by what their experts have to say about autism and what the capabilities, because it is such a broad spectrum. When we begin to talk about these people and how they view the world and their perception, can they be manipulated and controlled? That's going to be the key here.
This is a fascinating case on many different levels, and I do want to let all of our viewers know we have a feed into the Go to John courtroom right now. We'll show it to you in a second, but we want to let you know that we're going to take a quick break. And when we come back, hopefully we will be live in that courtroom. We're also keeping a very careful eye on the Armando Baptista trial as well. But you see it, right? That's the Nicholas Go to John courtroom. And as soon as it starts up, you're not going to want to miss it. There's so much to talk about. Let's take a quick break. We'll be right back. Okay, so Wendy, one of the weird aspects of this case that we don't see in a lot of other trials is we always want to sympathize with the victim. You know, we saw it in some cases where the photo is put right there for the jury to see constantly. Sometimes you see family members and friends called as the first witnesses in the case. This trial's different. She's not a sympathetic figure. In fact, we believe that there are no family and friends of Dee Dee Blanchard in the courtroom for her. So is this a situation where you may have to put, if you're the defense, the victim as not that sympathetic?
I'll tell you what, Jesse, you got to work with the facts you have, and those are the facts you have in a case like this. It is a horrendous case for all of the reasons that jurors are going to be able to learn about the smothering nature of this relationship, the abuse, all of the types of things that are going to make them sympathetic to the defense. So what do you do with that if you're a prosecutor? Now, the defense is they're making all the right arguments themselves in basically setting the scene for the human dynamics that underlied the decision that was made both by Gypsy and Nick to do exactly what happened. But here's the problem. There were options. One of the options that the defendant said that he thought of. Grab Gypsy and run. There doesn't need to be a murder, a loss of life here. The jury you can't get around that. There were other ways in which this young couple in love could have gone about extricating Gypsy from that horrendous abuse that she was enduring.
Yeah, okay, well, those are great points, and we're going to analyze that a little bit more, but we're getting a word right now that we are live right now in the Nicholas Go to John courtroom. A witness is on the stand, first witness of the day, so you know what we're doing? We're going live. Let's go. Okay, let's just talk real quick. This witness is just beginning the part of the testimony. Nothing too exciting yet. I want to bring back on Joseph Scott Morgan. Joseph, we were talking about victims here, right? And so what we talked about actually before we went on today is, at what point do you think Gypsy Blanchard realized that she herself was a victim? Because I'm wondering if the defense will say, hey, listen, she knew for quite some time. She was an active participant in this scheme to defraud the public in order to deceive the public. Or is it a situation where, yes, she knew she could walk, so she knew that something was off with that wheelchair, but she was deceived for quite some time. But then again, right when she had met her boyfriend, the boyfriend realized something was off. So at what point did she really know that things were off, and how much do you think the defense is going to capitalize on that and say, listen, she knew what was going on here?
Yeah, I don't know. It must have been some kind of epiphanal moment for her to come to this realization. Keep in mind, since she was a baby, this young lady had been on this trajectory her entire life. Essentially, this was her norm, that she indwelled. And so I can imagine that as her brain begins to mature, she's coming into reality. She's being exposed to the outside world. Let's keep in mind, the mom kind of kept her cloistered throughout this period. She was very particular about people that they would talk to. She would even, when she would go to the doctor's offices, she would insist on being in the room when any examination was being conducted. So it's hard to actually pinpoint, but at some point in time, she probably, as she got exposure to the outside world, she suddenly became aware that, hey, this is not a quote-unquote normal life I'm living.
Yeah, that's one way of looking at that. Joseph, stand by. We're going to take a quick break. When we come back, we'll be live back in the Nicholas Godejohn case, and I have two great guests to break it down with me. We'll be right back. All right, so as we analyze certain pieces of evidence, we got to get back to the main crux of this case. I'm back here with Wendy Patrick. And Wendy, one of the things we saw yesterday was the interrogation tape of the defendant. My question to you is, again, if you're sitting in the defense's chair and saying he can't form the requisite intent for first-degree murder, this is a guy who the prosecution is saying not only did he know what he was doing when he planned out this murder and actually committed it, but he's had sex with Gypsy before. He knew what he was doing. So how can we have it one way and not the other? You know what I'm saying?
I do, and that's the question the jurors are going to have to face as well, is it's got to be one or the other. In other words, he has the wherewithal to be able to decide what to do with his relationship with Gypsy, how to pursue it, and ultimately, that question that he was faced with at the end, the infamous angel and devil analogy, I love that. I just keep going back to that the prosecutor is in the opening statement introducing the thought to the jury that he had options. He recognized he had options. He had the wherewithal to think through and strategize the sophistication of the plotting and the planning, and actually went through with it just as he'd planned. That amounts to first-degree murder. Let's see if he can come back from that.
All right, we'll have to see. Let's take a quick break. When we come back, we'll be live in the courtroom. All right, let's break down what we just saw. First up, Joseph Scott Morgan. We saw a lot of interesting pieces of evidence when they were collected from the crime scene. I'm curious for your thoughts on that.
Yeah, and what this gentleman is describing is what he saw at the time, and this has been documented photographically, and it is what's really great about this, and one of the things I teach my students at Jacksonville State is that you are in fact a historian that is freezing a moment in time that can only be gone back to vis-a-vis these images that you've created. So it takes us back to that time and place when these events took place.
That's what makes crime scenes so eerie and strange when we look back on it. Now, Joseph, you're going to stay with me for another hour. We have a lot more to talk about, but Wendy, our time together is coming to an end. So I want to ask you a really important question. There are emotions in this case. People look, the reason it's drawn so much attention is we're not sure what to feel or what to think. But if you're sitting on the jury and you're listening to these facts, it becomes even more difficult for them to be an impartial jury, right?
It does. You know, judges always tell jurors, don't leave your common sense at the door. But what they never say is leave your emotions at the door, because we can't. And when you look at cases like this, where the emotional impact is so significant, there's a danger of it overriding the law. That's what we talk about when we talk about jury nullification. So the judge is going to have to be very clear that despite the impact, despite them understanding why Nick may have wanted to rescue Gypsy in this way from that relationship, how they still have to follow the law and make that determination. It's really going to come down to the medical evidence as to whether or not he could have formed that requisite intent. It looks bad for him factually, and the chronology of the timeline makes it look like he in fact did form that intent. But the defense has introduced the mitigation that they could find necessary, at least to bring down that crime from that very serious first degree.
Do you think that this is a situation where you put the defendant on the stand, or this is just way too many moving parts?
It depends on how they think he's going to do under cross-examination again. It depends on whether or not the disability he has is going to be so evident that it's going to be obvious to a jury that he didn't act with the wherewithal that's necessary. It's not an insanity defense, but it's still a mental defense that's a significant mitigant. And if, in fact, he's going to present that way and stand up under cross-examination, he's not disputing that he did it, then this is the kind of gentleman that may actually take the stand.
That would be fascinating.
It would be
to
fascinating.
See, one way or another. Wendy, thanks so much for coming on, and have a safe trip back to California. You got to come back out here.
You bet I will. Thanks, Jesse.
All right. So here's what we're going to do. We are going to take a break, but when we come back, we'll go live into the courtroom, and Joseph and I are going to break down the really important aspects of this case. We want to talk more about Munchausen syndrome by proxy, but we also want to talk about the defense's autism defense and what does it mean to be on the spectrum, and whether or not really this defendant could form that requisite intent needed for first-degree murder. That becomes the legal question, and we're going to ask it in a medical capacity. So let's take a quick break. We'll be right back. Stay tuned here on Law and Crime. All right, there's not a lot of activity happening right now in the courtroom, so it gives me a great opportunity to bring back in forensic death investigator from Jacksonville State University, Joseph Scott Morgan. Joseph, you had mentioned a great point about the shoes that we saw earlier that had this blood on them. They're believed to be gypsy shoes. Can you elaborate with our audience about what you were saying about those, the blood on there?
Yeah, if the audience will recall, we had the image of those white tennis shoes that were presented. We in forensics love white surfaces. They're very stark. And in this particular case, when you're looking at those shoes, if people can go back and kind of check this out, I hope we can get a screen capture of it. Those are blood droplets. Those appear to be consistent with, say, for instance, low velocity blood spatter. That means that that blood dropped from height, fell onto the shoes. This isn't like a transfer, like it was smeared or a contact transfer or anything like that. This is actually a droplet that free flowed, and there wasn't just one, there were several. So if folks in the audience will take a look at that, that's rather compelling, because what it does is that it gives us an insight into maybe the movements that were going on. Now, I don't know if those shoes were actually on her feet at the time. Maybe they were in proximity to the stabbing as it went forth, but that is rather compelling. Another point of interest is if we see the top surface of the shoes, it'd be really interesting to see the soles of the shoes, to see if maybe there was blood on the floor that the individual had stepped in and it transferred to the shoes. And this goes to the larger picture, doesn't it, Jesse? Referring to what was her level of involvement. He has stated at one point in time he had her go into the bathroom, cover her ears, all this sort of thing. But what was the activity, the actual activity that was going on when all of this occurred?
Well, didn't we get the sense that she may have helped clean up the blood and they had sex right after this?
Yeah, and that was one of the other things that was kind of interesting about this, and it made me reflect back. I'm kind of a forensic, I love forensic history, and one of the things that made me think back to was the Charlie Starkweather case back in the 50s, where you had the two young lovers that went on this killing frenzy that through Nebraska and some other states and whatnot. And one of the things that occurred in that event is that after this initial frenzy of the initial killing, they had sex in the house. There were bodies there, and it adds a whole nother level of creepiness to this.
Yeah. Pretty normal, pretty standard. Yeah, that's what we expect from this.
Yeah.
We're going to jump in court in a second, but before we do, just want to talk about some of the other things that we saw there. There were a number of wigs, and then we also saw that there was a lot of money with writing that says nest egg savings. Right. We saw a box of handcuffs. You know, these kinds of things, they're telling more of this bizarre story with the Munchausen syndrome and also what the murder was like. I mean, the killing was like. I mean, what do you gain from that perspective about the other things that we're seeing? And clearly there's going to be other evidence put forward. I do want to let our viewers know there is a meeting in chambers, we believe, happening right now, so we'll jump back in a second. But these other items that we found, including Gypsy's bag, what do you make of this?
Well, it doesn't just go to the actual event of the homicide, but it goes to something even more compelling. That's the planning of this thing. We've got handcuffs. We've got duct tape. We have all this other stuff, these elements that are coming into focus here. And when we put all of this together, it begins to paint this very grim picture of these two people kind of entering into this kind of confederacy. over a period of time where there's planning involved. Remember, this young man traveled all the way from Milwaukee to Springfield by a bus, and counsel actually pointed that out. That's a long time. That's a huge commitment, particularly for a person that has been diagnosed with autism. To see them get on board of a bus and travel outside of their normal safe area that they're in, in that spectrum of autism, one of the things that happens is that they love the control and the safety of the environment. It doesn't apply to all folks diagnosed with autism, but it's kind of a characteristic that's indwelling with them. They like the safety, the security of it, kind of the repetitive nature of things. They don't like things to change. And my God, Jesse, I cannot imagine a more dynamic environment to be in than being on a Greyhound bus traveling a great distance to an unknown future where you know that you're planning to commit a homicide. And that, for me, is just, wow, it's mind-blowing.
Prosecution definitely wants to establish that this was a deliberate act, that he thought about it, premeditated on it, could have made a different choice, but ultimately didn't. The defense wants to say, though, that he couldn't, because of being on the spectrum, he couldn't form the required intent needed under the law for first-degree murder. But isn't that an uphill argument? Because you're saying it yourself. He took that ticket. He went there. He planned this out. He had sex with her. He knew what was going on. In his police interviews, he said, I knew she didn't even need all this medication. So how can the defense ultimately say, and you, from a medical point of view, explain it to me, is it possible someone can be on the spectrum and able to do X, Y, and Z, but when it comes to being able to really understand or appreciate the intent for murder, it's not possible? Is that a valid argument?
I don't know. I think that it's a very difficult argument to make. I don't know how severe his malady is. I don't know if it's so affecting in his day-to-day life that he's that he's kind of entrapped in this world. It doesn't seem like it to me. It seems like he has the ability to have some level of cognition here. He's able to communicate electronically, and certainly able to communicate one-on-one with individuals. They even went, to the production or the movie together, where they're dressed and all these sorts of things. It just kind of breaks the mold of what we commonly think about the behavior of somebody that's stricken with autism in their daily life. I think it's a real uphill battle, Jesse.
Yeah, I mean, they had sex in the movie theater bathroom.
Wow,
it's pretty incredible. Yeah.
Yeah.
I know, it's nuts. But let's tell you what, we actually have a feed back in the courtroom. Let's go live. And Joseph, I'm so happy you're sticking with us because we have so much more to discuss. But let's jump live right now. Evidence Day, Evidence Day, Evidence Day. Back here with Joseph Scott Morgan. I want to ask you more about the Munchausen syndrome by proxy, though. Have you seen instances where the person who is ultimately not the victim of it, so you have the person who suffers from it, which you would say is Dee Dee, but the person that's the target of it, which is Gypsy, have you ever seen the target of that person, of that syndrome, turn on the person, their captor, in a way? That, hey, kind of like what happened here. Yes, she planned it with her boyfriend to do it, but have you ever seen the person who's the target of it turn on that person that suffers from it?
In my little spectrum of the world, no. It doesn't mean it hasn't happened, but from my perception, covering cases and as a practitioner, I've never seen it. I really haven't. It's an interesting kind of I don't know, kind of story that has developed out of this thing. I think that's why people are so drawn to this. This is a case that's in Springfield, Missouri, out in the heartland of America, and it's compelling because you've got this person that was essentially, I'll be the first to use the word tortured throughout her entire life, and suddenly you know, she kind of strikes out in vengeance. I think that that's one of the things that's so compelling about this, and it's so rare. I've just never seen it before.
That's why we're all trying to figure out who's the victim in all this.
Yes.
Dee Dee's the victim, but was Gypsy the victim? Was Nicholas the victim? We're all trying to figure it out. Joseph, stand by. Let's take a quick break. When we come back, we'll be live in the courtroom. All right, so it looks like they're going to go to break, which gives us a great time, me and Joseph Scott Morgan, to talk more about the details of this case. And Joseph, I want to focus on the testimony from yesterday of forensic investigator Thomas Vandenberg. He had the opportunity to observe the wounds sustained by Dee Dee Blanchard. We saw all these different wounds, stab wounds, very, very brutal attack here. I'm curious, though, the defense, under cross-examination, we're asking interesting questions about, can you tell us the order and the time frame of the stab wounds? When did rigor mortis set in? I'm curious, what were they trying to get at here? What is it? Why is it important to learn a little bit more about this?
Yeah, let's take a look at the wounds first, Jesse. When you begin to talk about this, they always ask us the question, the order in which the wounds were sustained. And that's very, very difficult to ascertain. Most people worth their salt are going to say, no, it's kind of indeterminate. And the nature of these wounds, there's so many of them. I think total number at the end of the day was like 17. You've got a combination of both incised wounds, which if folks at home will think about drawing a knife across the surface of something.
It's brutal. It's a
cut.
It's a brutal collection of wounds.
As opposed to a stab, which is, you know, a puncture wound. And it's a frenzied event. We've got them all over. However, they are in specific lethal areas around the neck.
Joseph, I'll tell you what. I want to touch more upon these wounds. I do. But right now, we are getting a breaking development right now in the Armando Baptista trial. We just got word that Demetrius Elder, the co-defendant, the one who was found guilty of culpable negligence, he's on the stand right now. Let's go live into that courtroom. All right, pretty interesting stuff there, seeing them, Gypsy and Nick, in that motel or hotel. Joseph, I want to ask you one final question because I know we have to sign you off. You were able to look at the ME's report, the forensic investigator report about the stab wounds. What'd you make of it?
Well, it's a rather frenzied event. We've got a combination of both incised wounds, which means cutting, and puncture wounds, stabbing. What I found rather compelling is apparently he drugged this knife across the surface of her throat in order to try to end her life. But, you know, he had her in a position where he was able to penetrate her chest multiple times as well as her abdomen.
Wow.
He had her in a submissive position, and it is very, very frenzied. It's
frenzied, and it's pretty brutal, Joseph. And I know we have to hit a break. I'm sorry, and I have to sign you off, but we loved having you on. Make sure to come back. Bob Bianchi signing in. Stay tuned here on Law and Crime.